Okay, hello, welcome everybody. It's 4 o'clock exactly, so I don't know how many people will have tuned in at exactly this moment in time. I'm going to say a few words to introduce what Sonia, Lenegan and I are planning to do today. We're doing it as a sort of live video version of our regular monthly podcast. Now, the difference here is not only are we actually appearing on video, but it's also live. So normally with the podcast, we have the luxury of fluffing things up and then going back and correcting things, and we don't have that luxury today. So you'll have to bear with us, and also bear with us on the reality that we haven't had this legislation for very long. So Sonia and I have been spending a long time going through it, analysing it, trying to work out how it works. There is a resource that we managed to get onto, or I managed to get onto Free Movement fairly quickly, which was a kind of initial look, which you can find on freemovement.org.uk. There's also now other resources which are available to you, and there are two that we'd particularly pick out, maybe three actually, one of which I haven't looked at myself yet. There's the ILPA briefing, the Immigration Law Practitioners Association briefing, which has been done by, I think, several practitioners and is very good indeed, very useful. There's also the House of Commons library briefing, which is a very substantial piece of work, quite dry, but that is the nature of these things. It's intended to be used for parliamentarians and so on. The other one which I haven't actually taken a look at, it's only just come back to mind actually talking now, is I think PLP, the Public Law Project, have put together a briefing as well. They're a very reputable organisation, and I imagine anything that they've done is probably worth looking at, although I have to say I haven't actually seen that myself yet. Right, so far it's just me talking. We often do this with the podcast as well. Sonia, will you just sort of say hello so that everybody,
I mean, they can see me today, so they know I'm here. Hi, everyone.
Excellent, excellent. So we've got a rough plan between the two of us to kind of cover several different things. So I was going to start by talking through the purpose of the legislation and kind of a quick outline of roughly how it works. Sonia is then going to try and talk through the process envisaged by the bill if it works according to plan, as the government wants it to work. And then we'll move to, will it actually work? What is likely to be the kind of real world impact of the legislation in terms of its deterrent effect and what actually happens to people and so on. And then we'll end with a discussion about the lawfulness. And when we say lawfulness, we don't mean lawfulness in domestic law, because obviously if you pass an act of parliament, it's the law, it's lawful. It's more its compatibility with international law. One of the points we'll be making at that point is that just because something breaches international law doesn't mean that you can't do it on the domestic plane. You can get away with breaching international law in all sorts of different ways. But there are nevertheless some interesting things to say about that, particularly with the European Convention on Human Rights. We've got a couple of questions that people sent in response to the weekly newsletter. So we'll try and come to those a bit later on. If you've got any questions that occur to you during this sort of session, try leaving a comment on the YouTube video. And Josie Laidman, who's the deputy editor at Free Movement, is trying to kind of look at those, parse them, group them together into questions for me and Sonia as we go. We're not quite sure how that process is going to work. We're not terribly experienced at doing this, so bear with us a bit. But if you do have questions, try and put them to us in that way, and we'll try and get to those at the end if there are any. Okay, so first thing we're going to try and do is talk through roughly what the purpose of the bill is and how it's what the kind of plan is in overview. So the core of the bill is that there are two duties that it will impose on the Secretary of State, the Home Secretary, if it becomes law, or when it becomes law, realistically. The first of those is basically a duty to remove, or a duty at least to make arrangements for the removal of certain people. And certain people is basically anyone who arrives unlawfully, in the sense of somebody who arrives outside normal UK immigration laws. For example, they're supposed to have a visa and they don't have one, or they're supposed to have leave to enter and they don't have it. or who obtains one, who does have one of those things, but has obtained it by deception, or anybody who overstays. So it's a very, very wide range of people. And some of the discussion that we've seen of this in the press and by politicians has focused on the idea that this is aimed at small boats and people arriving in small boats. And that's kind of true, but they are not the only people who are affected by this. And just to give you an idea of numbers, around 45,000 people arrived in small boats in 2022, but that was about half the number of asylum claims. And then on top of that, we have no idea how many people overstay. So the numbers of people who are affected by this are unknown, but it's more than just people who arrive in small boats. It's almost all asylum seekers, plus also overstayers if detected by the Home Office. So there's a duty on the Home Secretary to remove anybody who falls into that extremely wide category. And then there's a kind of follow-up duty, which is to deny them access to the asylum system if they claim asylum, and also to deny them any form of legal status ever. So they can never become a refugee or recognized refugee. They can never get leave to enter. They can never get British citizenship. And even in a really, frankly, weird and also cruel quirk, their children can never get British citizenship either in certain circumstances. So the idea is there's a duty to remove people, to make arrangements for their removal, and also they can never get lawful status at any point in the future. So one of the problems with this is that, and you know, there are a lot of problems with this. This is not the only problem, but one of the problems with this is that if you refuse people access to the asylum system, then you don't know who is a genuine refugee and who's not, because that's what the asylum system is all about. It's about deciding who's a refugee, who's not a refugee. So there will be no assessment ever in future if this bill goes through, or when this bill goes through, of asylum claims, because there will be no asylum claims, basically. And that means that normally the government would be at risk of sending people back to their home country who might then die or be persecuted, which the Refugee Convention is intended to avoid. You know, the whole point of the Refugee Convention is that that doesn't happen. And the government is dealing with that by creating basically two lists of countries, or arguably sort of three lists of countries in a way. So the first list of countries is at the new section 80AA. The fact that, for non-lawyers out there, and lawyers for that matter, you know, the fact that this section has to have two letters after it just tells you how amended, you know, normally it's 80, 81, 82, 83 and so on, but they've had to go back to a piece of legislation in 2002 and start using alphabet letters as well as numbers in order to kind of slot in all of these amendments into the right place in the ordering of the bill. So anyway, the first of these two lists of countries is a new section 80AA to the 2002 Nationality, Immigration and Asylum Act. And it is basically EEA countries, European countries, EU countries, plus a few extras, plus Albania. So that's that list of countries. And the idea is that nationals of those countries can be removed to their home country. So they can be sent back to their home country. And there's a kind of presumption, strong presumption, that they're not a refugee, that they're not going to be killed or persecuted if they get sent back. Or they can be removed to anywhere on the second list of countries, which I'm going to come back to in a moment. So they can be removed to their home country, or they can be removed to anywhere on a second list of countries. Also, though, before we get onto that second list, nationals of any other country in the world cannot be removed to their home country, because there's a risk that they would be killed or persecuted because there's been no assessment of their asylum claim, but they can be removed to any country on the second list. And that's one of the weird quirks of this legislation that we might come back to when we're talking about will it work, which is that at the moment, you know, let me just pull up the immigration stats from the Home Office in front of me now. So got a list here of the top 10 countries that are claiming asylum at the moment in 2022. And some of those countries have got a very high grant rate. So Afghanistan, it's 98% of people who claim asylum get asylum. Syria, it's 99%. Eritrea, it's 98%. So very few Afghans or Syrians or Eritreans would ever be removed back to those countries anyway. But there are some countries in that top 10 that have a much lower success rate. So, for example, let's look, Iraq, 56% success rate, and we're talking about roughly 4,000 people a year. So, about 40% of them, a bit more than that, would be sent back eventually if the asylum system was working how it should. 35% success rate from Bangladesh, slightly higher numbers, about 3,000 people from Bangladesh. India, only a 4% success rate. There's been a sharp rise in Indians arriving. It's about 3,000, I think, in the last year. So one of the side effects of this legislation is that those people, because they're not on that first list, they cannot be sent back to their home country. So normally, most Indians would have their asylum claim assessed, it would be rejected, and then they would be sent back, or at least they would be eligible to be sent back. But under this legislation, they won't be. And what the Home Office is doing is saying they can't be sent back to their home country, but they can be sent to anywhere on the second list of countries, which is a new list of countries at the schedule to the bill. It's very similar to the old clearly unfounded list, but it's not exactly the same. It includes, most importantly, the country of Rwanda. And the idea is that if you claim asylum from anywhere else in the world, basically, other than the list, other than the countries on the list at 80AA, you will then be sent to a third country on the second list in the schedule. So if you're from India, you wouldn't be sent back to India, you'd be sent to Rwanda instead. And clearly the idea is that this will deter people from coming. Whether it works or not, again, we'll come back to that issue later. So in order to achieve that, because if you start saying to people, okay, you're from India, but we're going to send you to Rwanda, you're from Afghanistan, but we're going to send you to Rwanda, and so on, the chance of them staying in touch with the Home Office is pretty limited. So the bill creates a very wide new power of detention in order to basically take people into detention as soon as they arrive. It doesn't force the Home Office to do that, but that's clearly the kind of process that's envisaged here. And then they're detained during the process, which Sonia is going to describe in a minute. So the Home Office doesn't lose track of them. They don't disappear into the community. And then they get subjected to this new process. So that's my quick sort of walkthrough of how the bill is intended to work. Sonia is now going to try and talk us through the kind of process that's envisaged by the bill. Over to you, Sonia.
Thanks, Colin. Just to make a couple of short points, in addition to refugees being caught by these 4 conditions, also victims of trafficking who may not be refugees, they will also be caught by this as well. So, that's concerning. That's another big group of people who are going to be affected by this. People who previously would have been recognised as victims of trafficking and granted leave will instead end up in this limbo process and subject to removal. I also want to say a lot in the bill remains unclear, and there will be far less scrutiny than usual as there is no proper bill committee stage in the Commons. That usually includes consideration of oral and written evidence. Instead, the government is using a committee of the whole House process. And so that means instead of the specialised bill committee doing this stage, it's all of the House of Commons, and it's been set down for 2 days. I'm not sure if the dates have been confirmed for that yet. But by way of comparison, the Nationality and Borders Bill had 8 days for committee stage in the House of Commons, and even that was considered insufficient at the time. Okay, so let's look at what this process will look like. I like to think of this as the fantasy version of how the bill is going to work. And then after that, Colin and I will look at what is far more likely to happen in practice. Also, no, I'm not going to go into, there's a lot of additional nuance and detail that I'm not going to go into, but just note that most, if not all, of the below can also be applied to a person's family members. So the starting point in this fantasy land has to be that functioning returns agreements are made with third countries. So we will assume that at least some of the list of countries set out in the schedule have agreed to accept non-nationals from the UK. So someone arrives in the UK. This could be someone from Afghanistan who was not one of the lucky, I think, around 72 people who were resettled to the UK from there last year. There is obviously no visa available for such a person to apply and come. So they have made the journey across the channel. And when they arrive, they come off the boat and they are taken straight to a detention centre, either on the grounds that it is suspected that they meet all 4 of the conditions, or because it has been concluded that they do meet the conditions in clause 2 and that the Home Secretary is under that duty to remove them. Just to flag up, the duty to remove is discretionary for unaccompanied children. So it doesn't mean that they will be subject to the duty to remove, but that can still be applied to them. And that is obviously hugely concerning. Once it has been decided that someone does meet all 4 of those conditions, the SSHD Home Secretary must also, under clause 4, deem the claim inadmissible to the asylum system here in the UK. There are no exceptions to that. There are no time periods after which the claim will be admitted to the asylum system, which is currently the case. It's usually after 6 months it will be admitted. So that's basically it for their asylum claim. It will not be considered in the UK. So what happens next? For the first 28 days of their detention, assuming the Home Secretary does decide to detain them for that long, they cannot apply to the first tier tribunal for bail. Habeas corpus applications are expressly still permitted, but I would advise people read Jed and Greg's article on free movement today on the detention provisions in the bill, which highlight the issues with that. Nor can the person make an unlawful detention judicial review claim during this period unless there was bad faith or such a procedurally defective way as amounts to a fundamental breach of the principles of natural justice. After the 28 days, they will be able to apply to the tribunal, or the SSHD could decide to release them. The powers to detain have been expanded considerably in this bill, which is really concerning. As there are return agreements in place in this scenario, it is likely that the person would remain in detention while the Home Secretary arranges their removal. Note also that the bill provides that detention can take place in anywhere deemed appropriate by the SSHD. So that could mean longer periods of detention in unsuitable locations, such as Manston. So, what we saw last summer could very easily happen again. The next step would be that the person is issued with a notice of removal stating where the SSHD intends to send them, so to which country. And again, there are the 2 country lists. The first one is at clause 50, which is EEA countries and Albania. If you are from one of those countries and you make your claim, you can still be sent back there unless the SSHD considers that there are exceptional circumstances preventing removal. That is the current situation for EU countries, but obviously Albania has now been added to that list, which again is concerning because it has a relatively high grant rate, especially for certain groups, such as I think women and children. But yeah, so you can still be sent back to your country of origin unless it is accepted that there are exceptional circumstances. And then in relation to the second country, which is the list of third countries that a person can be sent to, our person is from Afghanistan. They will not be returned there as it is not in the list of countries, but they could be sent to any country listed in the schedule. So the notice of removal will state which country they will be sent to, and it will advise them of the process to make submissions as to why they should not be removed to that country. Now, as we saw with Rwanda last year, people were getting these letters and they just had no idea what it actually meant. I still remember, I think, reading a news article and, the person just didn't even know what Rwanda was. I think they thought it was another bit of the UK or something. Anyway, so yes, the process to make submissions as to why they should not be removed, that is referred to as a suspensive process. It means the person cannot be removed from the UK until the process has concluded. There are 2 types of suspensive claims that can be made. The first one is a serious harm suspensive claim, that the person faces a real risk of serious and irreversible harm if removed from the UK to the specified country. I think it's clause 38, that's serious and irreversible harm, and that is a placeholder. So I think more details should be forthcoming about that. The second type of suspensive claim is a factual suspensive claim, that a mistake of fact has been made in deciding that the removal conditions were met. Either claim must contain compelling evidence and be submitted within 8 days of the person being given the notice. And the Home Office then has 4 days from the date of that claim to make a decision. These timescales are not conducive to the proper preparation of such a claim, especially with this compelling evidence requirement, and nor to it being considered and a proper decision being made. I mean, how is the Home Office going to do this properly within 4 days? There are provisions for making those claims out of time, but I'm not going to go into detail about those. As far as legal aid is considered, this is not mentioned at all in the bill, contrast to the Nationality and Borders Act, which did have provision for legal aid. But, you know, even if these claims are in scope of asylum work, which I'm not sure if they are or not, given you haven't made an asylum claim. I don't know if anyone knows the answer to that. By all means, put it in the chat. But even if they are in scope of asylum work, there aren't enough lawyers available to do it, to pick up such urgent work in high volumes. And so these people will be navigating this process unrepresented. So then when the Home Office makes their decision on the suspensive claim, they can accept the claim. But remember, this is just about removal to that country. The person's substantive asylum claim has still been deemed inadmissible. Or they can reject the suspensive claim. That decision can be appealed to the upper tribunal, or they can reject the claim and certify it as clearly unfounded. In that situation, so where you've been certified, you can apply for permission to appeal to the upper tribunal. That will be decided on the papers unless the upper tribunal considers an oral hearing is necessary to secure justice. So on the papers, probably. An appeal or application for permission to appeal must be lodged within 7 working days from when given the notice of decision or the grant of PTA, permission to appeal. The upper tribunal must then make a decision within 23 working days for an appeal or 7 working days for a PTA. A decision to refuse PTA cannot be challenged. Refusal of an appeal can be appealed to the Court of Appeal. Permission for that obviously subject to meeting the relevant test, which is not straightforward or not easy. There is also a placeholder clause at 49 saying that the SSHD may make regulations around interim measures made by the European Court of Human Rights, presumably to say that there is no need to take account of any interim order made by the European Court if they had said that a person should not be removed from the UK. So a person at this stage is either removed from the UK or they are not. If they are removed from the UK, there will be a bar on their lawful return. If they succeeded under the factual suspensive claim argument, then I expect the SSHD would remake the removal decision without the factual error. If they succeeded on the serious harm basis, then presumably they would not be removed to that particular country, but an attempt may subsequently be made to send them to a different location. In the meantime, their asylum claim remains inadmissible. If they are not removed from the UK for who knows how long, there is provision at clause 29(3), I think it is. Yeah, that inserts a new section 8AA to the Immigration Act 1971. And there are provisions in there for the SSHD to grant leave to enter and remain where necessary to comply with ECHR obligations or where there are compelling circumstances to do so. There is also provision to grant indefinite leave to remain, but only where necessary under the convention. So we have no idea how that is going to work in practice, but you know, there is provision for leave to be granted, not refugee status, but leave of some unspecified form. And then there is also a bar to British citizenship, not just for those who meet the clause 2 conditions, but also for children who are born in the UK on or after the date of 7th of March 2023 to parents who met the conditions. So for example, if someone arrived after the 7th of March, they had a child in 10 years' time, they're probably still in limbo, and that child would not be entitled to register as a British citizen. So yes, this is the grand plan. Now we're on to, will it work?
Yeah, thank you, Sonia, if that's the right word, because it's pretty depressing just sort of hearing all that again out loud and going through it. What we're talking about is this effectively abolishes the asylum process, and as Sonia was kind of not saying directly there, but one of the things it sort of dawns on you gradually, well, there's a role here for the upper tribunal. There's no role for the first tier tribunal. So effectively, this is more or less abolishing the immigration asylum chamber of the first tier tribunal. Not formally, but there's going to be virtually no work basically for the FTT anymore. And the other thing, just to sort of pick up on that, so this serious irreversible harm process, this applies, I think I'm right in saying, to people from both the Section 80AA list of countries and also all other countries. And so it follows that not only is this a way of resisting removal to a safe third country, it's also your way of resisting removal, your only way of resisting removal to your own country. So this is going to become the de facto asylum process. So instead of you having months potentially to prepare, to be interviewed by the Home Office, to put forward a case in consultation with a lawyer. So, for example, you're from Albania, for example, where we know that half of Albanian claims previously were succeeding. Admittedly, that's people who entered in previous years, not in 2022, because of the time delays that we're seeing with the asylum system at the moment. But we know that there are successful asylum claims from people in Albania. There are some genuine refugees. In fact, as many as 50% of people who were entering in previous years. If they're facing removal to Albania now, instead of having access to the asylum system, the only way they will be able to prevent refoulement back to Albania, where they may suffer persecution, is through this serious irreversible harm process. And it's also the only way that if you come from one country on the list, and this is something that Sonia raised with me when we were talking about this before. If you come from, for example, Ghana and you're gay and you're resisting removal to, say, Kenya and you're gay, this is the only way that you would effectively be able to claim asylum on the basis of removal to this, supposedly safe third country. So how that's going to work in practice when, there's these extra thresholds that Sonia's been talking about, such short timescales, you're detained for the whole thing. There's not going to be likely to be access to a lawyer. It seems highly likely that some people who've got good cases, basically, for resisting removal, either because they're a genuine refugee in respect of their own country with Albania, or they would face human rights breaches if they were sent to this supposedly safe third country, that just won't come out as part of this really foreshortened sort of quasi asylum process where it's all on you to put forward your case, as opposed to a kind of shared duty with the Home Office where they actually interview and stuff like that.
Even where they do interview, we know that there are issues with screening. So we've seen that with Napier, for example, and also with Rwanda. They're rushing people through the system so quickly. Screening it, for those sort of things is absolutely falling by the wayside. And obviously they won't even be screening here. It's just, it's just going to be a horror show.
Yeah, it's mind-blowing. And it's I think I might have said this in the blog post I wrote. It's now exactly 30 years since the Immigration and Asylum Appeals Act 1993 was passed by a Conservative government and sort of gave proper access to an asylum appeal to people, because it was important that people actually had proper access to the full asylum process, including the appeal, because it was all being litigated through the High Court and so on instead, and we're going kind of go back to an even worse situation, sort of predating that. So, big question now is, will it work? And Sonia, if you've got something you want to sort of chip in on this, then I don't know, wave a hand or something as well, because I think it'd be really useful to have some input from you on this as well.
Well, yeah, I mean, the first thing is returns agreements.
Yeah,
it all stands and falls on that, as far as I'm concerned.
Yeah, so that's why you said it's a fantasy process at this point in time, because there's nowhere to remove people to, basically, and I suppose that could conceivably change. But even then, the first flights the Home Office is expecting to take off to Rwanda, if it wins, if it succeeds in the Rwanda litigation, the first flights aren't expected until very late 2023 or early 2024. And even if those flights do start to take off, everybody who has arrived in the meantime, everybody who's arrived from the 7th of March onwards will be subject to this duty, will have no access to the asylum system and can never be granted status in the United Kingdom. And so one of the big questions is going to be, how many people is that? So ignore the process going forwards for now, just for a second. If similar numbers arrive to 2022, that was 89,000 people arrived to claim asylum if you include dependents. That could be another, that many people basically could have arrived in the meantime. We don't really know what's going to happen. The Home Office seems to be banking on this legislation and the threat of this legislation deterring loads of people from coming, but we've just got no evidence that that's really going to be the case. And I don't, speaking for myself, I can see it's conceivable that once flights do start to take off to Rwanda, if that does happen in future, that might put off some people from arriving, at least arriving openly anyway. I'm going to come back to that in a moment about the kind of unintended consequences of this, perhaps. But in the meantime, it's hard to believe that it's really going to deter really anybody. So we could be talking about tens of thousands of people in this new backlog that has built up in the meantime, who are in theory going to be detained and forced onto a flight to Rwanda by the Home Office. But there's very little prospect of that really happening as far as we can see. So there's going to be a lot of people around. They can't be detained in the meantime because there's no prospect of removal. So even with this new power of detention, once it becomes law, it just doesn't seem likely or really conceivable that they could be detained pending some imaginary future removal to Rwanda. And so they'll be released into the community where the Home Office has an obligation to continue to support them because they've got no other means of support. They're not allowed to work or anything like that. They'll never get asylum. They can't be recognised as a refugee. And so, at the moment, people are actually, in some ways, that's not that different to what happens to people when they arrive at the moment, because they're being put into this long backlog. It's years before they'll get an asylum decision. But at least they know at the moment that they will get that decision. Whereas this future cohort, anybody who arrives from the 7th of March onwards, they can never get asylum, and therefore they've got no reason at all to stay in touch with the Home Office. And what we'll probably see is people just going underground. They'll probably disappear, get jobs in the kind of sort of grey economy. There's a much higher risk of exploitation. There's much more risk of modern slavery. And there'll be widespread destitution as homelessness. Charities will be trying to deal with this as best they can. So that the short-term consequences for just the cohort before there might be any questionable sort of serious deterrent effects at some point in the future, that's quite a substantial number of people, and it's pretty bad. Basically, it's pretty bad. Does that sort of match with your understanding, Sonia?
Yeah, I mean, this whole retrospective element is just nuts because there are people here now who this legislation will apply to. And, does the government think that this draft bill is going to deter people? Because they are still coming, and that by the time the bill passes, it may be tens of thousands of people. There is no incentive on the Home Office to do anything to progress or decide those cases. So what happens, is that just going to be yet another backlog of people that just sits there? And then once the bill has passed, then, already there are tens of thousands of people who are in this situation, who can't access leave and who will require support. What's the grand plan? It's baffling.
It is baffling. I mean, genuinely baffling.
It's my least favorite combination of things. It's stupidity and cruelty.
Yeah. And there's a kind of segmented backlog building up. So Rishi Sunak made this pledge to clear the backlog, but the small print is it's actually, by backlog, he just means people who'd arrived prior to commencement of the Nationality and Borders Act 2022. So what was the date of that? Was it the 30th of July?
28th of June.
28th of June. So he's saying that we'll get all those cases decided by the end of 2023. But of course, there's loads of cases, loads of applications that were made between then and the 7th of March. So there's kind of a segmented backlog there. And then there's all the people from the 7th of March onwards who get no prospect of any asylum decision ever on their cases now, basically all people who are arriving now. So yeah, it's going to be a very substantial number of people, we think, tens of thousands of people, and a lot of them will probably have disappeared as well. Some will presumably stay in contact with the Home Office because they'll be receiving support that way, but some won't want to take their chances. The risk of removal to Rwanda at some point in future will be such, and they'll just be so bored. There's no reason to hang around, basically, that they may well sort of disappear. And then going forwards, the Home Office will, if this plan works according to the Home Office's kind of fantasy of this all sort of happening and there being removals to third countries being possible at scale. Because we've talked about removals to Rwanda. There's been coverage that there might only be a few hundred a year. The government seems to think that it can be scaled up, as they put, that thousands of people could be removed. But the idea that they'd be able to remove all of the people who've arrived since the 7th of March, and then also everybody who arrives afterwards, however many that may be, perhaps smaller numbers than we've seen previously, but not zero. There'll still be some people probably trying to come in. That seems very unlikely. And I think one of the things that I think it's really important to get across here, but it's really difficult to get across, is just how difficult it is to conduct those removals. Because, removals are very easy to talk about in theory, but in practice, they're violent, they're messy, it's obviously coercion, and it's hard enough for the Home Office to remove people back to their home country, a country that they're familiar with, when their asylum claim has already been decided, and exhaustively so. It's gone through an appeal process and so on. It's hard to conduct removals in those circumstances, and people can be very resistant to such removals. But I think it takes it to a whole new level when people will be facing removal to some country that they've got absolutely no connection to at all, and where they've got no realistic economic, social future in that country. People will be very resistant to removal. We're likely to see fight back literally. We're likely to see violence. We may see horrible incidents of self-harm and even suicide. People will be really desperate. And forcing those removals through is going to be extremely challenging for the Home Office and for the people who, it's not that I feel terribly sorry for them if this is what they've signed up to, but the people carrying out those removals, that is going to be a really messy business, and that's understating things really radically. What do you think, Sonia?
The other thing I worry about is in relation to trafficking. We already know that traffickers will use laws like this. They will use the threat of Rwanda. They will use these new laws to keep control of the people that they're exploiting. So, that is something else that needs to be borne in mind when MPs are voting through things like this. I also wonder about, because, they know people will go underground. So I wonder about the expansion of GPS tagging regime. It seems that there is the potential for private companies to make a huge amount of profit off the back of this bill, and the amount of outsourcing that's going to need to happen, also in relation to the detention estate and the size of that will be needed. I guess accommodation centres are still potentially going to be a thing. I don't know. It's just the horrors seem endless.
Yeah, so I can see we've had a few comments on the YouTube channel that I'm sort of trying to vaguely keep an eye on, as well as also talking to you and looking at my notes and keeping an eye on everything else. So it's not.
I can't multitask that much.
Yeah, but Bill McKeith has asked, am I right? Unless there's a huge increase in immigration detention places, the government will not be able to carry out this plan, and that's surely right. And there would have to be a substantial. Assuming that this doesn't deter everybody. So obviously, if this deters everybody from coming to the UK, the government's got no problem going forwards because there's no people to detain or remove or whatever. But my assumption is that that's not going to deter everybody, and that and therefore, large-scale detention will be necessary. And that means a massive expansion in the detention estate. And when I was looking at the stats on this the other day, I think I'm right in saying it's about 600 asylum seekers detained at any given moment at the moment. But it would have to be, substantially bigger numbers than that in future.
I think Refugee Council have done a briefing with all of those numbers. I think they were saying the size of the detention estate would need to be 9,000-ish.
Yeah, because if you look at the number who are in detention at the moment, that includes people who are facing deportation. So it includes foreign criminals as well. Failed asylum seekers aren't a big cohort of people who are detained and removed at the moment. Mostly the people who experience detention who are claiming asylum, it's on initial entry, and it's for a short period of time to establish their identity and so on. But one of my fears about this, and something I've only really started to think about, I think today actually, is how people will try to avoid this happening to them. And one risk that occurs to me is that people at the moment, if you're crossing in a small boat, then you're aiming to get, as I understand it, you're aiming to get halfway across the channel and then call for help, basically. You're hoping to get into UK waters and then get assistance, and then you'll be taken to a place of safety and essentially rescued at sea. Well, I wonder if people will stop trying to do that, and instead they'll aim to try and make illicit landings. So people will try and get all the way across the channel, instead land secretly, not be detected by the authorities, and therefore not go into detention, not be monitored by the Home Office and so on. And obviously the risks in doing that are far greater than, it's bad enough getting into a small boat and trying to get rescued. That seems like taking a really big risk already. But to try and get all the way across the channel illicitly seems like a much riskier journey, where you're more likely to have people drowning. Although presumably you'd also have less people trying to make the journey. So, and how the calculus of risk and death and so on works in those kind of circumstances, I can barely even imagine. But yeah, I mean, the big problem, and you started with this, Sonia, the really big problem with this plan is that there just doesn't at the moment seem to be a safe country to remove all these people to. The backlog of people that arrive from the 7th of March, plus everybody who arrives once flights to Rwanda start off, it seems inherently unlikely. Although I'll flag this up as well before we move on to talk about lawfulness and sort of finish off this segment on will it work. It does look a bit different, I would say, if there's a deal with France. So if you have some sort of wide returns arrangement with France or with the EU, then I guess if you were aiming to remove pretty much everyone back there, I guess this is the kind of system that you would want to design. Whether the French would be willing to do that, considering they have so many asylum claims there compared to the UK, essentially willing to say to the UK, yeah, it's okay that you don't consider any asylum claims when we consider all these ones. I doubt, frankly, it seems a bit unlikely.
Exactly.
But yeah, it's conceivable that could happen, though, I suppose. And being detained for a sort of 28-day period, or however long it takes to then remove you back to where you start from, is, I think, at least in theory, and that's less objectionable than being removed to Rwanda, a country that you've got absolutely no connection with at all and have no future. Okay, so I think our answer to will it work is a big fat no, really, when it comes down to it. As far as we can see, it doesn't seem likely to deter people in the short term, and then even in the long term, it may deter some people, but it may also force other people onto even riskier routes to get to the UK.
Yeah, I'm skeptical it will act as a deterrent at all. But I think basically if they try to operationalize this without having, not just Rwanda take a couple of hundred people, but, safe, whatever, returns agreements that will take the correct number of people, then it's just going to be chaos, because we will end up with people, thousands of people just sitting in limbo, for years and years and years, and they will need support. It's just, we just need to see what's going to happen with the returns agreements, because maybe the government does think that something is going to happen there. It certainly doesn't seem likely. I mean, I can't imagine why France would do that at all. But, in the absence of that, this is just an absolute disaster waiting to happen.
Yeah, it's one of the things that I think I'm really struggling with this bill, is that it yeah, I'm used to not liking the government's immigration legislation from my point of view, because it takes away people's rights and so on. But I just don't see how this works for the government either. And
No.
that's it's like you were just saying a second ago, where unless they've got something up their sleeve essentially that we don't know about, just on the face of it, this legislation looks like a really bad idea from the government's own point of view, because either it doesn't work, in which case they look incompetent as well as cruel, and there's this new backlog of people who can't ever be removed anywhere, basically, or it works and then they have to actually carry through these really violent removals of loads and loads of people, which is very hard to do, and it's not hard to imagine harm and death resulting from that. So it just I just wonder whether we're missing something here. It just doesn't seem to make sense, basically. Yeah. Okay, so on that happy note, well, the fourth segment here that we were going to go through is to look at sort of how compatible this is with the UK's international law obligations. And Sonia, you were going to lead on this segment, I think.
Yeah, sigh. I mean, no, it's not compliant with our international law obligations. Refusing to allow refugees access to the UK's asylum system, that is a breach of the Refugee Convention. I don't really see how otherwise can be argued. Article 31 of the Refugee Convention says that people should not be penalised for their illegal entry or stay. That's exactly what this bill does. The stuff on ECAT, the European Convention Against Torture, that's really, I mean, so flagrant. Again, it's just refusing to allow survivors of modern slavery and trafficking access to, any sort of assistance and help and support in this country. It's so shameful. The bill says people who have received a positive reasonable grounds decision that they may be a victim of trafficking, they can still be removed. Any requirement to grant leave to remain does not apply. So you can see under this bill that people will be getting a positive reasonable grounds decision, and then the Home Office will be trying to remove them, and probably they will be detained this whole time. I mean, adults at risk will presumably still apply to people who are detained under this bill, but as we've already discussed, things like screening and, they will be missed. So yes, it is going to breach ECAT. It is going to breach the Refugee Convention. I mean, the government has written to MPs. I think the Home Secretary said that there's over a 50% chance that it breaches the European Convention on Human Rights. They have disapplied clause 1.5 of the bill, disapplies section 3 of the Human Rights Act, which is to say that the bill must be read and given effect to in a way which is compatible with convention rights. And I suppose I'm straying on to enforceability here. If you can't have your convention rights protected by the domestic courts, then you'll need to go to Strasbourg to get that done. Enforcement for breaches of the Refugee Convention and ECAT are a bit more difficult, to say the least. What do you think, Colin?
Yeah, I absolutely agree. But with the proviso of kind of from the government's point of view, so what?
Well, quite.
So, with some international obligations, there's no enforcement mechanism. And so there's nothing, if the government is in breach or in arguable breach, there's just nothing that anybody can do about it. And the Refugee Convention, unfortunately, falls into that category. So, it's only the second of the big kind of human rights treaties that was negotiated and drafted after the Second World War, and it doesn't have a good enforcement mechanism. It's got, I think it's Article 38, one signatory state, ratifying state, can take another one to the International Court of Justice. That's never happened. Australia's been getting away with similar policies for a long time. That's just not going to happen, probably. And, so if the UK is in breach of the Refugee Convention, which surely it is, because there's no, again, this is sort of one of the weaknesses of the Refugee Convention. There's nothing that explicitly requires states to decide who's a refugee and who's not. it's obviously implicit in the convention, because otherwise, why would all these people have all these rights that are then set out at sort of Articles 2 to 35 and so on? And the definition is there at Article 1. But there's, it's actually a bit of a struggle in kind of domestic law interpretation terms to point to the bit of the Refugee Convention that's breached, because it's the whole of the Refugee Convention. It's like the spirit of the Refugee Convention, which really matters in international law. So obviously it's incompatible, but it doesn't matter because the government can get away with it because there's no way of forcing them to comply. And unfortunately, ECAT seems to fall into a sort of similar category where there's no way to force them to recognize that their interpretation of public law grounds. So there's this weird kind of rather disingenuous, I think they know from the explanatory notes to the bill, they know this is really dodgy. And they say that, look, we don't have to grant people this recovery period if there are public interest grounds, public good grounds, basically. And that's obviously intended for an individual assessment. But they're sort of using this they're pretending that there's a wide scale emergency in the UK, uniquely amongst all signatory states to ECAT, all states that ratified ECAT, when in fact, the number of claims is increasing, the number of asylum claims is increasing across Europe at the same time. And, it's just obviously in breach of that. It's an obviously dodgy interpretation, but I don't think there's anything we can do about it, at least under ECAT itself. And it's different, though, with the European Convention on Human Rights, which does have a kind of international enforceability because of the European Court of Human Rights. So there is a court to adjudicate these issues when it comes to human rights issues. And this is not my area of sort of speciality. I think, Sonia, you're better on this stuff than I am. But, Article 4 of the European Convention on Human Rights has been interpreted as protecting victims of trafficking, and there are arguments that it kind of implicitly incorporates some of the protections of ECAT, or at least equivalent protections to ECAT. So there's some scope potentially for the government to be found to be acting unlawfully in not offering any kind of protection to victims of trafficking. Do you think that's a sort of reasonable assessment?
Yeah, I think so. I'm sure someone will let us know if we're getting it all completely wrong. I just dug up the justification given for essentially the breach of ECAT. They've said the justification is based on a number of factors, including the pressure placed on public services, the large number of irregular arrivals, and the loss of life caused by arrivals from illegal and dangerous journeys, including via small boat channel crossings. People are not being trafficked, well, not necessarily being trafficked across the channel. People are trafficked in a lot of other ways than that. So, the justification seems very thin, although really what could be justification for treating people who've survived modern slavery in this way is beyond me.
The journalist Nick Cohen at the weekend in his newsletter had a line about Rishi Sunak being the first prime minister in 200 years to oppose the protection of victims of slavery. And I think that sort of outlines the scale really of what the government is doing. They're kind of deliberately saying, victims of modern slavery won't be protected, and we won't do anything for them.
I saw we've got another question. I don't know if you've got anything else to add on that.
Yeah, and before we do that, so there's a couple of things on ECHR. So the detention stuff, I reckon, is pretty dodgy in terms of compliance with European Convention on Human Rights. So kind of the idea of people being detained for quite substantial periods, basically for administrative convenience, probably with very limited, if any, access to a lawyer, and where it's not for their own good. Which bear with me on that. That looks like it's probably incompatible with kind of Article 5 of the European Convention on Human Rights, the protection against arbitrary detention, and the kind of case law that we've seen in Article 5, like the old Sardi case about the old Oakington process. And they were able to say that the Oakington process was compliant with Article 5 because it was detention for a short time, about 7 days. You had access to a lawyer, and it was for the purpose of deciding your asylum claim, which was for your own good, and it was also for the good of other people who were claiming asylum as well, that you got a fast decision. But just none of that applies in this new situation. So I think they're on pretty dodgy ground there. And then there's also the serious irreversible harm stuff. It's quite, one of the quirks of what the government's doing here is that they do have a kind of out of country protection mechanism for human rights claims already at the moment, which the words serious irreversible harm are already used, but they're an example of when it's unlawful. And so the Supreme Court in a case called Chiari and Bindloss looked at the existing kind of mechanism, said that it could be lawful if it was properly operated by the Home Office, although it wasn't. But they didn't look at the meaning of those words, serious irreversible harm, because it was only an example of when you cannot remove somebody. And so, one of the things that the Home Office is doing here is they're using terminology that hasn't been decided in the domestic courts, hasn't really got a definition either in Strasbourg. And so there's bound to be litigation as to what it means, which is kind of inviting this whole thing to be bunged up in the courts and therefore not to work, and therefore to have really substantial numbers of people building up in this kind of new backlog of people who will never be removed and also have no incentive to stay in touch with the Home Office. So that kind of meaning of serious irreversible harm, potentially that could be problematic as well. Okay, so let's see if there's any questions that we think we can address before we wrap this up in another sort of.
One through from Josie that I can take very briefly. Someone has asked, will there be a larger number of applications after 20 years in the UK? Or do you think people will try to keep, I think this means avoiding the Home Office? And I think it's clause 29. If you meet those 4 conditions, you will not be granted leave to remain. So you can't apply even after 20 years, assuming that rule still exists then. I think that's what the question means.
Yeah, I think that must be right. So I think the problem is that the person who's asking the question, because they're learning about this as as part of this process, the problem with is that they don't understand that this prevents you from ever getting status. It's an exclusion from ever being granted lawful status in the UK, which is such a change from the existing law and the existing, how things work at the moment, that I think it is genuinely difficult to get one's head around how radical that is. Yeah. How would it be possible for international obligations to be enforced? I think we've kind of dealt with that.
We covered that one. Yeah, that was asked before we did that section.
Right, I'm just scanning through the comments. Appears to undermine Refugee Convention, ECAT and others. Tia Lily, yes, it does. Claire Dunn saying, I really doubt that all asylum seekers follow the news and the smugglers aren't going to tell them. Well, yeah, absolutely. And that's why we think the deterrent effect is unlikely to kind of kick in. Christopher Huff, surely the ECHR will strike down this horrible proposal. Labour Party could confirm they're going to repeal it after the next election. That's 2 very separate questions there. I mean, the ECHR can't strike down the whole thing. And I think it's been quite cleverly designed in some ways so that it's kind of arguably compliant. It'll be litigated, but it's not clear who will win that litigation. As for the Labour Party, I mean, this puts them, I think, in some fairly serious difficulty, because if this goes through, assuming Labour win the next election, which is what the opinion polls seem to be telling us, this creates a massive problem for the future government, because they've got tens of thousands of people who are currently, that the law says cannot be granted status, but also cannot be removed. If a new Labour government was to turn around and say, okay, well, we're scrapping this law, then of course, the media will go berserk, even though by then it should be abundantly clear to everybody that this was never going to work, and it's a really stupid law, basically. Any thoughts on that one, Sonia, or do you not want to go there?
I mean, no, I'm very happy to go there. Labour absolutely needs to adopt a humane approach to this situation, and it's not just about enforcement and focusing on people smugglers, etc. These are genuine refugees. We should be proud of the of the fact that the UK is prepared to offer protection to them. And there's nothing exceptional about the UK. Why should we not comply with our obligations where the rest of the world do so? And, there are countries in Africa who take a hell of a lot more people than we're being asked to. It's shameful. And if Labour don't oppose this very strongly, I think that position is shameful. They need to commit to getting rid of this if and when they are elected, because, also, if they don't, they really are going to store up even more of a problem for themselves. They need to get rid of it as quickly as possible. Otherwise, those people are just going to keep stacking up and stacking up and stacking up. And at some point, something is going to need to be done in relation to regularizing their status, because they're not going to be sent anywhere. So, yes, I do have some thoughts.
Thank you. And I think it's an example, isn't it, where like the right thing to do and sort of liberal, thing to do, the nice thing to do, it's actually the practical.
Well, exactly. That's why, yeah, exactly. It's just common sense as well as being, the kind and humane thing to do. So from both of those perspectives, Labour really just needs to commit to getting rid of this.
Right. On that note, I'm not seeing any more questions coming through, so I'm sorry if we haven't answered your question, but we're hitting the hour, which seems like exactly on the minute, actually, as I speak. So it seems like a good time to wrap things up. Sonia, have you got any last thoughts that you want to share?
Yeah, I'm going to get changed and head to Parliament Square, so hopefully see some of you there at 6. Anyone who's watching live. Otherwise,
Excellent.
You missed it. Sorry.
And my apologies for not being there. I'm in Bristol, so it's a bit of a long way.
Yeah, you've got
I'll be there in spirit.
No one else does.
All right. Thanks very much, Sonia. And I'm going to stop the live stream now. So thank you, everybody who's tuned in, and we hope that was helpful.